Number 119, matter of World Trade Center disaster litigation. Counsel?
May it please the court, Andrew Amon for the state of New York. I'd like to request 2 minutes for rebuttal, please.
You may, sir.
Thank you, Judge. The Battery Park City Authority seeks the benefit of a special shortened time bar given by the legislature only to public entities. Yet BPCA claims the rights of a private entity to challenge legislation temporarily lifting that special public entity-only time bar. The legislation in question, commonly known as Jimmy Nolan's Law, was an eminently reasonable
Let
exercise.
me start with, are all public entities are the same, in your view? In other words, municipal corporations, public benefit corporations, political subdivision, they're all treated the same?
They're certainly not all treated the same for all purposes, but under this court's analysis in Black River Regulating District and the Third Department's analysis in Capital Off-Track Betting Corp., there's no reason to treat public benefit corporations different for purposes of applying the general rule that power conferred by the legislature confers no vested right as against the legislature itself. Jimmy Nolan's Law, in any event, also was reasonable and would satisfy the test of reasonableness, or indeed any due process test, because the law was a narrow, limited measure to aid recovery against public entities by a discrete and deserving class of workers.
There's been a discussion that, the Second Circuit, I think, suggested it, that we have two tests here, and I think Chief Judge Walker and Eli Lilly have suggested the same thing. What's your view on that?
Whether there are two tests or one test when there is a private entity against whom claims are revived is an issue that this court need not resolve to settle this case because it's only a public corporation. But in any event...
So the standard would be different for a public corporation, assuming they get through capacity. The standard you would apply in testing whether or not this extension or Jimmy Nolan's Law passes muster would depend on the party?
Yes, that is something that we think could be relevant. We also, just to answer your question, think that the relevant test is reasonableness, no matter even if it is a private defendant. It's just
Okay.
pointing out that need not be
But
decided.
as I read those cases, a few things strike me. And in the 1924 case of Robinson sets out this analysis, then Galuski kind of rehashes Robinson and interprets it, and then again in Eli Lilly there's the suggestion, well, those two tests are different, but it doesn't seem to me so much that those two tests are really different. I mean, you could read those two earlier cases as saying there has to be some type of extraordinary circumstances. In one case it's the workers' comp repeal, in the second it's World War II. And then Eli Lilly applies that stricter test. But there has to be some extraordinary circumstances. There has to be a blameless plaintiff, or however they phrase it. And then you look at that. It's almost like a Fourth Amendment analysis. You look at that to see if what has the legislature done that's reasonable. So I have some trouble with saying it's either this heightened extraordinary circumstances test or this much lower reasonableness standard, when I think you can harmonize those cases. And I think that's what Galuski was doing.
Galuski certainly said that it was deciding the case within the framework of Robinson. Galuski also said, that a claim can be upheld where there are exceptional circumstances and in a serious injustice. Right. Our point is that the injustice need not be as extreme as the particular one in Galuski to satisfy the statute.
Those are semantic glosses, in essence, on the original test that was in Robinson.
Correct. And the original test that is in Robinson is also satisfied here.
Well, that would be consistent, wouldn't it, with McCann and Heimowitz, right?
Yes, absolutely. You have here, as in McCann, a group of plaintiffs who even though they had the benefit of a symptom discovery rule, had to act within 90 days of discovering symptoms. And the type of symptoms that they, first noticed would could easily be mistaken for a cold or sinus infection. If
But
they don't,
that really goes to satisfying the test, right? So what I think the circuit's just asking us for is are there two tests and which one should we apply, right? So your facts in this case may fit one or the other, or maybe the same test for both. But really the issue for us is, what's the test? And that should
No,
apply for everyone, or maybe not for public benefit corporations, I guess.
no, that's absolutely, you're correct, Your Honor, in terms of what the circuit certified to this test, or certified to this court. We do in any event think that no matter what standard is applied, this statute meets it.
Yeah,
The-
unfortunately, we
as
can't
to
do that
the-
here, right? The way they
What's
did
that?
in Eli Lilly. We can't do the Eli Lilly fix here, because they're not asking us, does it pass? They're just asking us, what's the standard? So in effect, we have to either choose or say it's the same standard, right?
With respect, the circuit did say that the court could expand the questions, but
Well,
assuming that the
I thought
court
they only said that on the
chooses.
first question. I don't think they said that on the second question.
No, I believe the language did.
Well, the rule lets
respectfully.
us modify or not answer, do whatever we want with the questions, but
Yes.
our role here is not to decide the ultimate question that is presented in a federal lawsuit that has exclusive jurisdiction over these kinds of cases. It's
under-
just to tell them what our state rule is.
Understood. And the state rule, the reason that these circumstances are relevant, that make this a compelling case to revive claim statute, also speak to why the standard is reasonableness and not that you have to have something that was as extreme as in.
So is there any circumstance, switching subjects back to where you started, is there any circumstance where a public benefit corporation can sue the state challenging a legislative act as unconstitutional?
There are certainly the exceptions that have been noted in the case law in which a municipality or other political subdivision can challenge the constitutionality of a state law. And
Those
there,
are a grant from the state directly, right? Are they usually a grant?
a grant from the state directly or the subdivision has a viable claim that by complying with the statute, it will, by that very act of compliance, be forced to violate someone else's constitutional rights.
You're talking about the exceptions to the capacity to sue rule, right?
Yes.
Okay.
But isn't
And-
there a fifth exception, if you will, that, comes out of, that we should apply some sort of a particularized inquiry? I mean, you see that being done in the Community Board 7 case, where you look at you're going to look at the enabling statute, you're going to look at the legislative history, and you're going to try to determine from that, I mean, isn't that really, if you will, a fifth exception?
If there is such an exception, it doesn't apply here. Any particularized inquiry is dictated by the fact that the same circumstances that dictated the outcome in Black River Regulating District and Capital Region Off-Track Betting Corp. Are satisfied here. It's also satisfied because even if we were to say that there needs to be a particularized inquiry, in this case, Battery Park City Authority is claiming the right of a private party
Well,
to
getting
challenge.
away from, oh, I'm
Yes.
sorry, go ahead.
To challenge against legislative encroachment the benefit of a notice of claim requirement that was conferred on it specifically because it was a public entity.
That's not what I thought you were going to say, but it's a good point. No, my question is in those cases where we've applied this particularized inquiry test, were any of those where the entity was attempting to sue the state to declare a state statute unconstitutional, or did they all involve protecting the municipal entity from lawsuits by third parties, essentially?
The particularized inquiry line of cases to which Battery Park City Authority refers none of those cases involves the situation you have here of saying are they a creature of the state with rights to enforce as against the state itself?
It's sort of like a sword versus a shield kind of analysis, to simplify it in my mind. We've applied that particularized inquiry test when they were trying to use it as a shield, not as a sword against the state that created them in the first place.
Yes, that's correct, Your Honor.
But going back to your other point that you made before, basically that the BPCA is availing itself of privileges unavailable to non-governmental entities by using the 58th General Municipal Law. Is
Yes.
that the point you were about to make?
Yes.
Yeah. And so if our ruling was based on that, or if our analysis was based on that particular point, does it matter which due process standard we rely on? The reasonableness or particularized inquiry?
That would dispose of their ability to bring the challenge, but as far as reasonableness goes, a few other things that I'd like to just point out very briefly. Battery Park City Authority was created by an affirmative act of the legislature and exists and operates solely under the grant of legislative authority to serve public purposes that are specified by the legislature. It doesn't have any private shareholders, owners, or directors, and therefore, its bondholders bought their bonds while Jimmy Nolan's law was already on the books.
Can
So
you
there's no-
just tell me about the debt, though? They incur debt that the state is not responsible for, correct?
Yes, as
Okay,
do
what
all
difference?
Sorry.
What difference, if any, does that make then in the analysis?
It doesn't make a difference because all public corporations, including municipalities, incur debt that are not guaranteed by the state. Also, the rights of the bondholders are not asserted here, nor could they be by BPCA alone, nor are they infringed because, again, the bondholders bought their bonds when this law was in effect.
Well, we don't really have to decide this question, right? This is, again, the question for us is how the Second Circuit can figure out whether or not BPCA has capacity to sue. The question for us is not whether indeed they have capacity to sue, correct?
It is not, but I was actually making these points in reference to get back to the question of what standard should apply.
Yeah, you're making the point as to how the Second Circuit would make that determination.
Well, and to how this court might answer the question of what standard applies substantively to the due process challenge if BPCA has the right to bring it. And that point is simply that under these circumstances, there are no private interests to balance against the public interests that the legislature.
Well, if indeed the suits are allowed to go forward and BPCA loses, who loses money in that?
The Battery Park City Authority potentially would have to pay, but the Battery Park City Authority, by definition, everything it has is held in trust for the common good. Its profits inure to the state of New York, the benefit of the state of New York and the people thereof. There are no private holders, no
What do the
owners.
bondholders get out of that then? Anything? Well, why purchase the bonds?
Do they get tax-free bonds?
What do they get?
They get a debt they get the right to be paid by Battery Park City Authority, but that is the same for any city, any contractor, and there's no infringement here of any right. They bought these bonds knowing that this law was on the books and that Battery Park City Authority could pay claims if they were found to be liable.
Thank you, Mr. Amon. Counsel?
May it please the Court. My name is Daniel Conley from Bracewell, and I represent the respondent, Battery Park City Authority. I think I would start with just by saying Judge Garcia's question is the exact right question. And is there one standard? Is there two standards? And the jurisprudence of the state is really quite clear that there is one standard. Claims revival statutes are extremely rare in this state. They are, as the court told us, as this court told us in 1922, an extreme use of legislative power. Every case that has followed in the almost 100 years since then has followed a similar fact pattern that a serious injustice had to be addressed. So I agree to a certain degree that the question was asked in an open way in the Heimowitz or the Eli Lilly case, as Judge Garcia refers to it. It was asked in an open way, is there two standards? And then they say, well, there's serious injury here, so we're not going to go and make a decision. But the truth of the matter is, the case that
Doesn't that suggest that maybe there is? Because otherwise, wouldn't you just say there's only one standard?
Well, I think what it suggests, Your Honor, is a careful, if there were to be a second standard, the so-called reasonable standard, it would have come, if it came from anywhere, from Robinson versus Robbins Dry Dock. And when you read Robinson versus Dry Dock, which I know we all have very carefully, you can see that it's addressing a serious injustice. Every piece of the language, both factual and in the legal support of it, hews to the notion that this is an extreme use of legislative power, and subsequently...
I don't know that that goes to the question whether or not that forecloses something that falls short of a serious injustice, nevertheless being upheld as an appropriate revival statute.
Well, I think that, I agree that that sort of begs the question that the Second Circuit is asking. They find themselves in a circumstance, in truth, this court has never held a revival statute to be unconstitutional, so it's hard to see what would miss the test. Having said that, I submit to you this court has never seen a revival statute quite like this, on a basis as articulated by the state legislature as thin as this. And so...
What about the argument that the test ought to be lax or ought to be towards reasonableness at least because the statute claims are being revived against a public entity?
I don't think there's any support for that notion. I think this goes to another critical question, and it blurs the two questions, but that Judge Fineman raised at the very beginning, which is, are there differences between municipal corporations, political subdivisions, and public benefit corporations? And the answer to that is yes. And furthermore, there are differences between public benefit corporations. And so, the notion that there is a one-size-fits-all test or that all public benefit corporations can be treated one way,
Well, let's assume that's not the case, that they can be treated differently for different purposes. I think isn't the question before us, for purposes of this particular capacity to sue rule, what should be the rule? We have certainly found in other cases, or whether explicitly or implicitly, this particularized test was applicable, but they've never, as far as I'm aware, applied to this capacity to sue rule. And particularly in a case where the entity that we're talking about has asserted a time limitation that only governmental entities can assert. So why isn't it appropriate for us to take that into account?
So just if I can back up one quick second, the notion, it's been said a lot, how Battery Park City asserts the notice of claim protection. But to be clear, that is a power that is given to it, not because of general municipal law, which all municipal corporations have that benefit under 50E. Not because of that, but because of a particular section of enabling legislation. So the state can give that power. And so it does not have that power inherently. It's going back to what Judge Fineman said, it's not like a fifth category. It's a separate category.
Yeah, I don't know, I was on the council in Buffalo for a long time, and every public benefit corporation I thought had that power given in its enabling legislation. I never saw one that didn't have that standard, the 1-year, 90-day standard. I thought that was a standard part of the packages. The differences are usually the powers they have, the projects they're going to work on, whether they're doing real estate. Anyway, the differences are set out for policy reasons, but not for procedural reasons primarily.
No, I think that's right. There have been some in the history of the state that don't have notice of claim,
Okay.
but I would agree with Judge Fahey that there aren't, at least not that I'm aware of off the top of my head, there aren't too many that don't have that. But that's not the point. The point is that you look at the particularized makeup of, in order to answer the question, you look at the particularized makeup of the entity you're talking about.
That's generally been in the context of whether other parties, third parties, can sue or assert different rights against the public benefit corporation, not the other way around, not whether the public benefit corporation can sue the state to declare its law unconstitutional.
I think that's right, Your Honor, except that what the analysis leads you to is, what the particularized inquiry leads you to, is what this court talked about in 2011 in the Bordelot case. And in the Bordelot case, it said, this court has consistently recognized public authorities as legal entities separate from the state and joined in existence separate and apart from the state. So what happens, the result of the particularized inquiry, you're responsible for your own debts. You have all your own money. You can do things that the state can't do. The result of that is it creates in the entity, the public benefit corporation entity, in this case, a legal entity separate and apart from the state. And the question is, what does that mean? Well, it means it has the powers that other legal entities would have, including the power to challenge the state legislature, or legislation from the state.
That's sort of, to me, that's sort of a circular argument.
Except, and I don't mean it to sound that way, because what I'm suggesting is that in evaluating what are we looking at, we're looking at a public benefit corporation. Not all public benefit corporations would not be political subdivisions. You can have a public benefit corporation be a political subdivision.
We
For example,
decide
the
as a matter of
MTA.
public policy that we do not think that this particularized inquiry test should apply to public benefit corporations suing the state to declare a statute unconstitutional.
I'm sorry, the question was?
Could you make a blanket rule, I think?
Could
is,
we make a blanket rule? That's
right.
right, yeah.
Just say
As a matter of
a public benefit corporation can't do what it's trying to
Constitutional
do here.
challenges.
Well,
Constitutional.
if the court did that, it would essentially do violence to the notion of the public benefit corporation. Keep in mind that public benefit
Well, if we
corporations.
limited it to this particular context.
Well, in limited, you would still be, with respect to, so for example, one of the key elements of public benefit corporations is their ability to raise money through debt, through public debt and bondholding. So if you were to take away that level of independence, I forget, I think Judge Fahey asked, or Judge Wilson asked, does it matter that they collect their own money? Or that they're, I'm sorry, Judge Rivera, that they're responsible for their own debts. Well, it matters enormously. That's one of the key factors you have to determine.
Well, presumably, if one of the exceptions to the rule applied, it would still apply here.
Exceptions meaning,
Capacity.
Capacity.
with respect to like a municipal corporation. Well, I would submit, and the exception would be a particularized interest in a specific fund of money. But that whole analysis is in a different
It's a
category. That
vested
relates-
interest, not a particularized interest, right? It's a vested interest.
Well, I mean, there's I think, another whole avenue of discussion.
Well, I
we
just
could
don't want
have.
us to confuse which are the exceptions and perhaps some fifth exception. I want us to be clear as to what line of cases you are relying on.
And that's exactly the
It's
point.
a confusing area enough.
Yeah, exactly. And
Do
my
you
job
think-
is not to help add to the confusion. I think you're exactly right, because there is a distinction. There are 4 recognized exceptions when a municipal corporation, something like the City of New York, can challenge the state. And it's, when, we all know the four exceptions.
If
One
we
of them is-
said that's the answer, let me just say this. If we said that's the answer, those lines of cases, that's the answer to certified question 1, would it be the first time that the court says that approach taken in that line of cases applies to a public benefits corporation?
I think it might be, and I think it blurs the line. I think Your Honor is exactly right that we're talking about 2 separate things. This is, those are the exceptions available to a municipal corporation or a political subdivision of the state. That is not the basis upon which the Battery Park City and other authority and other public benefit corporations enjoy their independence. The jurisprudence of this.
Even though you're merely a creature of the state and
Well,
nothing more?
Yes, I mean, that's exactly what
You're a
this.
fiction, other than the state says otherwise, right?
I will say this.
Perhaps not you.
I will say this, Your
You
Honor.
are quite real.
I think we're quite real. I think we're all quite real. But in 1978, this court said in the John Grace decision, the mere fact that the entity is an instrumentality of the state and as such engages in operations which are fundamentally governmental in nature, does not inflexibly mandate a conclusion that it is the state. And that's really the point. The point is, it's another category, public benefit corporations. This court has said this repeatedly from the beginning of time, that public benefit corporations can be non-political subdivisions, and as a result, as recently as in the Bordelot case, are legal entities that enjoy the powers and that other legal
So
entity would have.
what is can you give me an example of a lawsuit we would want a public benefit corporation to be able to bring to invalidate a statute on state constitutional grounds?
So this one, the circumstances would be if the state were to pass a law that somehow did violence to the responsibilities, duties, obligations of the public benefit corporation, you would want the public benefit corporation to be able to challenge that, because if you didn't have that.
In a way that affected third parties, or that's irrelevant?
Well, to the extent it affects third parties, I think is relevant, but not critical to the analysis. I think there's an effort to try to distinguish this Patterson case, where it appears the Court of Appeals found that a public benefit corporation which had demonstrated its independence and consequently
Can the state eliminate the BPCA?
It can, but with restrictions, again. So it cannot, as we stand here today, the state of New York could not dissolve the Battery Park City Authority because it has outstanding debt. Now, could it?
Obligations to third parties.
Exactly.
But counsel,
Okay,
That's in the.
can
That's in
I
the-
just, I want to focus you just for 1 second on the due process challenge, because what I'm wondering is, Gallowitz, serious injustice, Robinson, reasonableness, is there a difference between those two terms? And, let me ask this, because we use the phrase serious injustice. What we're talking about is essentially a descriptor of injustice, and this court really can't measure injustices. We don't do that. So these terms don't really seem to be in conflict, and I'm wondering if we can't measure the differences between them, does it matter in your due process argument?
I think that question is really a central question and critical to helping the Second Circuit understand how to move forward. I think the answer to your question is that the standard matters to the extent that it makes clear that there's a recognition of the due process rights of the entity as against the extreme legislative power, extreme use of legislative power.
Could we tell the Second Circuit that they mean the same thing?
I think the jurisprudence of this court allows you to say that there is no circumstance in our jurisprudence, in the Court of Appeals jurisprudence in New York State, where a claims revival statute has ever been permitted for anything less than the serious circumstances or the serious injustice articulated in every one of the cases, from Robinson, where it's the workman's compensation issue, to the the latent disease and the latent disease
And is
issues.
that as a matter of law? That is to say that if the legislature thinks it's a serious injustice, but I might not think it's a serious injustice, who gets to make that decision?
Well,
Under your analysis?
in my analysis, at the end of the day, the legislature does what it does, and it has to be reviewed by the courts because it implicates constitutional rights. And in those circumstances, the state legislature has demonstrated historically an ability to create claims revival statutes that pass constitutional muster. This just happens not to be one of them. This is a circumstance. I mean, let's take this analysis to where they really want us to go, which is that one of the stated reasons, against a constitutional principle, one of the stated reasons for the necessity of this law is that these plaintiffs were unaware of the deadline, of the statute of limitations. If that passes constitutional muster, then no statute of limitation will.
Well, there's also
would be
questions about whether or
resisted.
not they were misled and so forth related to the actual risks involved in participating in this cleanup under the circumstances in which they worked.
Right, those are other rationale. And again, I don't mean to drag us
That's
into
what I'm saying.
Yeah.
If that is what persuaded the legislature, isn't the job done?
Well, no. I think the court has its traditional rule, or traditional role, I should say, of evaluating the standard. And here, we have a very, very clear roadmap written over decades and decades of jurisprudence from this court of the kinds of things that happen. And I just want to say one last quick point on this, which is that in evaluating this, and evaluating what the other courts, the older courts were looking at, is since 1986, this state has a discovery, it operates under the discovery rule versus the exposure rule. I suspect that there hasn't been, there will not be a valid challenge in the aftermath of CPLR 214E, a valid claims revival statute under these bases, because the legislature has already accounted for that serious injustice, whether it be caisson disease or DES exposure or what have you. And it deals with that not only in 214E, but in 214E4, it provides ample opportunity for plaintiffs to have access to the court. And so under those circumstances, evaluating the action of the legislature, and indeed, the legislature has never sent this type of claims revival statute. It's never been reviewed before with these facts. It simply can't pass muster.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Good afternoon. May it please the court. I'm Luke Nickus from Boies Schiller Flexner on behalf of the Alvear plaintiffs. I'd like to take my very short time to address two critical decisions the district court made, and I'd like to do so in the context of Judge Rivera's question about the serious injustice standard and who ought to be making decisions about that standard and how it applies in the particular case, for the purpose of focusing the court on how its choice of the test and how it answers the two certified questions, and in particular the substantive due process question, will implicate the decisions that gave rise, for my particular clients, to the Second Circuit's certification. And so I'd like to do so first by focusing on the district court's conclusion that a serious injustice did not exist because my particular clients had the benefit of the discovery rule under 214C. The court's conclusion in that respect, and it's right in its view to go to that question, was error. The discovery rule in a latent defect or latent injury case was designed for the purpose of protecting.
Again, these are the merits of your argument. I think perhaps of the argument you're going to make in the federal court, but the issue perhaps you're raising here, and that Judge Rivera I think was raising, is do the courts look at the serious injustice issue, whatever the merits of it is, or do we defer to the legislature? That's the general issue that's here, and that I think Judge Rivera was speaking to. But should we do that with reasonableness too? Why do we apply any standard? If the legislature thought it was reasonable, who are we to say it's not?
Sure. So the question, the answer is the court should defer to the legislature with respect to making judgments about what a serious injustice. Of justice. That's correct.
The court should defer to the legislature.
Well, the reason is illustrated perfectly in these cases, because when the district court evaluated whether an unjust circumstance occurred, whether an injustice occurred, it did so contrary to the legislature's judgment on two fundamental grounds that were wrong. When you look at, for example, its evaluation of the discovery rule, it concluded these plaintiffs under New York law had the benefit of the discovery rule because they had the right to toll this, to invoke tolling on the grounds that they weren't aware of their injury. And the problem is, in this case, these plaintiffs' injuries occurred shortly after 9/11, in 2003, for example, for Alvear, and the benefit of tolling under the discovery rule did not apply here, and the benefit of the additional year under the causation provision of that rule.
Those are all, again, the facts of this case. But the general question is, do we look at that and then come to a conclusion that what this legislature did is reasonable, or do we just leave that entire analysis, whatever the facts are in a particular case, to the legislature, and then just say, hey, you know, what they did, is that reasonable, without us engaging in any review of the analysis that supposedly the legislature has done over extraordinary circumstances, or however you want to phrase a heightened scrutiny.
You should leave that judgment to the legislature, Your Honor, and you should ask the district court to do the same. Because if you don't, two reasons. One, you lead the district court into an area where it has no standards for determining what an injustice or whether an unjust result has occurred. And that's what happened here. What is a serious injustice? The legislature...
Wasn't what the Court of Appeals was doing here in Robinson and in Galuski, wasn't that a review of, yes, the legislature certainly could look at whether the workers' comp scheme had been overturned by the Supreme Court. Yes, they could look at World War II's effect on the ability of this plaintiff's estate or whoever to bring that claim. But we didn't, in those cases, say, we don't have to worry about those facts because the legislature's already considered them. At the end of the day, we just have to say, is this a reasonable extension? Like, we didn't do that in those cases, so why would we do that here?
What you did in those cases is you did peek behind what it is to be reasonable in the particular circumstances. But the question is, how much deference is the legislature entitled to? And in this particular case, which your decision will implicate, what are the factors that you need to look at to determine whether an injustice occurred? And is the court equipped in this particular case to do that? And in other words, here we've got an injustice or not based on whether the plaintiffs were aware of cause.
Didn't we do that in what I call the Eli Lilly case, which I guess others call something else, but didn't we do that in Eli Lilly? I mean, didn't we do that exact analysis in a case that's more analogous to yours?
Your Honor, here the case is distinguishable because you've got a situation where the underlying facts in the case that the court put a burden on my clients to demonstrate. Did the plaintiffs in this particular case, in this litigation, introduce evidence that they were unaware of the cause of their injuries? And if those particular plaintiffs did that or didn't do that, then we can take a step back and test whether the legislature made a reasonable judgment, if that's going to be the test, in deciding that these particular plaintiffs deserved a remedy. And so the problem here in looking at the prior cases for this is that the underlying judgment here, the underlying judgment of injustice was done by the district court by burdening the plaintiffs with producing evidence to support the legislative judgment. And that's that type of reverse as-applied challenge. Make the plaintiffs show that as applied to them, the statute is constitutional, is not an approach that this court has ever adopted. No federal court has ever adopted that approach in a due process challenge. And in this case, because those facts were within the record or not, and that's what the district court did.
Isn't that the Second Circuit's business? I mean, really what they're asking us is not to approve or disapprove of how the district court applied anything. They're asking us what the test is.
It is the Second Circuit's business ultimately as to how to apply that test in the circumstances. But the test you choose, will it require serious injustice and what implications that will have for the underlying application? The test you choose, is it simply reasonableness, and we can harmonize your initial decisions about this issue by saying you look at what's reasonable when you then decide, peeking back behind that test, whether there was a serious injustice and the legislature made a reasonable judgment about that. The test you decide in this case will impact what facts the district court's looking at, whether it's permitted to look at the facts in the record of these particular cases to decide injustice, and the guidance that I respectfully request you give in the test that you create is that when the court looks at what's reasonable and not arbitrary, and whether it decides to harmonize a serious injustice standard or not is separate and apart from that. But when the court makes its judgment in applying that test, it is not the prerogative of the district court to shift the burden to look at the facts in this case to the plaintiffs. And this applies not just in when the district court says, did these plaintiffs create a record of their absence of knowledge, which is problem number one, but it also was what occurred when the district court said, let's also look at New York law and figure out whether this discovery rule fills the gap that the legislature sought to fill in enacting the Jimmy Nolan law. And what I mean by that...
Is that because you think the legislature already made the facts? They've already decided the facts? Therefore, the district judge could not make separate and independent factual findings specific to your clients?
that-
Legislative facts, is that what you're arguing?
I'm arguing that the Jimmy Nolan law is a blanket protection based on a legislature's judgment that this group of plaintiffs as a whole deserves protection against the injustice that would result. And they did that because the plaintiffs were uniformly affected by the public message that the EPA put out in early 2001, 2002 with respect to the quality of the air, that the New York City mayor had put out with respect to the safety of the working conditions, that the confused medical records and research demonstrated in 2005 and 2006 when there was uncertainty. And the legislature made a reasonable judgment that given those facts, it was within its authority and was reasonable to create this law to fill that gap. And if you don't leave that judgment with the legislature, then what you're doing is you're shifting the judgment that the court needs to what the court needs to do, and that is figure out whether this particular plaintiff can create enough of a record to put him within the intention or the scope of what the legislature intended to undo, or the injustice it intended to avoid.
Thank you, counsel.
You're welcome.
Mr. Amon?
Hi, just two quick points. First, the particularized inquiry test that Battery Park City Authority relies on so heavily has never been applied to hold that a public benefit corporation is anything other than an agent of the state.
Couldn't you look at it in a way, I think Judge Stein was getting at, we could do this as a policy matter, but you could kind of look at this to me as, okay, we're going to apply the particularized inquiry test, and anytime one of these corporations is challenging the constitutionality of a statute, you lose.
We have no objection to that characterization, certainly. And there's an important underlying policy consideration here, because allowing public benefit corporations, in particular allowing BPCA to bring its challenge here, would seriously undermine the legislature's ability to supervise.
Counsel, let me just ask you, so just to be clear, so the state's position is that, as a general matter, public benefit corporations do not have capacity to sue unless they fit under the 4 exceptions that the court has set out?
Yes, that's
Okay,
correct.
so now let's just stay right there. So why isn't then, as I was listening to counsel for Battery Park City Authority, why isn't what he's describing as this particularized inquiry really akin to some of these exceptions, but really framed towards the fact that this is a public benefits corporation and not a municipality? So it sounded to me almost like the suits by municipalities to protect their constitutionally guaranteed home rule power, sort of their interest in protecting whatever rights they have as this entity that you created, right, to protect the function for which they exist.
Yes, but the function.
Again,
Sorry.
all I'm suggesting is it possible to look at the particularized inquiry as something that properly responsive to the creature the state has created? I'm with you on that. You've created this fiction. And to the extent that there's something instructive in this line of cases with these 4 exceptions, there might be something that's an appropriate exception that fits for them.
That's entirely possible, but we have nothing of that character here because we have the same characteristics that led this court to conclude in Black River Regulating District that there was no capacity to sue, and the same thing in Capital Region off-track
But
betting
then are
court.
you conceding that we should make this inquiry in every case?
We don't think there is a need for this inquiry to be made in any case. If, however, the court is concerned that there might someday be some public benefit corporation that has some really distinctive feature, the court need not go that far. On the policy ground,
But I thought you agreed that if they fit under any of, well, obviously not the one on home rule, that they fit under the exceptions, that then they should be treated like the municipalities along those same lines of cases.
yes, that's true.
Okay, so
But-
you're already then conceding that it is possible
Yes,
for
it's
them in
that.
some case to have capacity to sue? Because, again, the
Yes,
question for
that's-
us is not to decide whether they do in this case, That's for the Second Circuit to decide. It's just what is the test?
And the test is, they fall under Black River Regulating District and Capital Region Off-Track Betting Corp., which puts them in the category, the same category as a municipality.
And then
so that-
all I was asking is, would it not be appropriate for the court, given what these 4 exceptions reflect, to perhaps recraft 1 or 2 of them to respond to the Second Circuit's question about how you treat a public benefits corporation, given that it is not a municipality?
There is no functional reason to do that, and doing so would potentially seriously undermine the legislature's ability to supervise public benefit corporations, which actually have less autonomy than municipalities, and it would therefore thwart the legislature's ability to continue to oversee these entities to make sure that they're continuing to serve the public interest. If I could just make one final point.
You may.
On the due process standard, this court has repeatedly, both in Robinson and Galuski, referred to due process in this context as a constitutional limitation of doubtful application. It requires a degree of injustice. Calibrating how much injustice, as Judge Fahey pointed out, is not something that courts are particularly calibrated to do. And in any event, whatever standard of injustice applies, however it's been described, McCann makes clear that where a claimant could reasonably lose their right to recovery because they failed to recognize the cause of their injuries within the time between when they discovered their symptoms and when they had to ask, there's an injustice.
Thank you, counsel.
Thank you, Your Honor.